President Cyril Ramaphosa suspended advocate Busisiwe Mkhwebane from the Office of the Public Protector. Mkhwebane will remain suspended until the Section 194 process, considering her fitness to hold office that has taken place in the National Assembly, has been completed. Last week, Mkhwebane responded to President Ramaphosa about why she shouldn't be suspended, in which she argued the President couldn't suspend her because he was himself conflicted and there is a legal process underway. The presidency says the decision to suspend Mkhwebane is in the best interest to protect all constitutional institutions. We speak now to political analyst, Professor Dirk Kotze, professor in political science at the University of South Africa. Thank you so much for joining us, Professor Kotze. Much appreciated. Perhaps I should start off with that the president saying that not only is he, but advocate Mkhwebane, it's incumbent on them to put the country's interests first, for them to respect the Constitution, and this is for the best. Do you agree with that sentiment?
Well, I think he quotes from the Constitution in that respect, and he says, well, that definitely applies to this particular situation. So this is not something which he formulated himself in saying, oh, this is the way in which I understand it. It's a confirmation of what the Constitution says he's supposed to use as the yardstick for a decision like this. So in that sense, I think the fact that the process has commenced in Parliament after a prolonged period of waiting and contestation by the current public protector. So there was quite a lot of preparations that took place, as well as the opportunity that he gave her to present her case to him why she should not be suspended. So I think in that sense, the procedural component of this, I think to a large extent, they have been complied with.
So is the Constitution then, explicit as to when and how the president should deem it fit to suspend the public protector? Because you say it is clear in the Constitution, he doesn't have to interpret that. But isn't there a value judgment or some form of interpretation where it says what would be in the best interest of the country? I'm not saying it's a wrong decision. I just want to try and understand when you say he's being guided by the Constitution. Is it that explicit? Does it say under these circumstances you will then have to suspend her?
No, it's just one sentence which says once the process has commenced in Parliament, and that applies also, for example, to the Auditor General if the person in that position will go through a similar procedure. It's not only for the Public Protector, but for all positions within the Chapter 9 institutions. There's no discretion sort of ascribed to the President. It says simply, once it starts in Parliament, then the President can suspend that person.
I mean, the President went on to say that the absence of advocate Mkhwebane would not impede the progress of any investigations that are pending or underway. So is this further confirmation of this, that he's made a practical decision, knowing full well that the law stipulates that the Deputy Public Protector will then take over?
Yes, I think this is in his intention. His intention is also to demonstrate that there's not going to be any vacuum left by the suspension, and that there's not an automatic person or person who will automatically take over as in an acting capacity for the work that the public protector must do. So in that sense, I think what he demonstrates is that it's not necessary, for example, to go back to Parliament, so that Parliament can identify or fill the gap that's been left if the incumbent public protector is suspended for this period.
Now, Professor Kotze, there are those who are saying the move by the president is surprising, given the fact that the public protector has even herself pointed out that the reason while she was furnishing reasons on why she should not be suspended, one of them was that the process is still undergoing legal, scrutiny. So the public protector arguing that Ramaphosa is conflicted and therefore could not suspend her. Was the decision to suspend her now surprising, knowing that there was going to be an outcome to that legal process tomorrow?
Well, I think what is the main factor that really set this whole process in motion was the fact that Parliament started with the procedure again. They held it on in abeyance for quite some time while many of these legal challenges were first heard by the courts. And when the courts made their final pronouncements or their judgments, then ultimately Parliament and the Speaker of Parliament of the National Assembly decided to continue with this. So I think based again on that, that was as well as the fact that the President Ramaphosa sent to the letter to the Public Protector to say she must state her case. Obviously, she said, well, this is why I think it should not be implemented, the suspension. But sort of in terms of the objective procedures that were followed, Parliament actually decided to proceed. And then President Ramaphosa followed on in that respect. So I don't think he must take full blame or full responsibility for the fact that they've continued with it. It is a joint decision, I would imagine, between Parliament as well as his office.
I mean, the presidency has put out a statement saying in all that he's done so far, he's fulfilled his obligations towards the public protector. So in terms of procedure, you say he's followed the letter of the law. The public protector has gone on another avenue to try and stop her impeachment by she has approached the African Commission on Human and People's Rights, accusing the Republic of South Africa of violating her rights by seeking to remove her from office. So given what we've just said, what you've just outlined, will she then find a favor or a sympathetic ear to this argument?
Well, I don't think that commission has any jurisdiction in South Africa in terms of judicial processes. So they can't, for example, set aside what any of the courts in South Africa have decided. They can express an opinion, but that will remain an opinion and very much less or more than that. So ultimately, when the Constitutional Court, we know it's the highest legal authority in South Africa, when they have pronounced on this matter, that's more or less the end of the story. And I think most of the matters that the public protector have challenged, some of them were successful. For example, the fact that there were not rules of procedure to implement Section 194. The same applied also to the impeachment of the president, and then President Zuma did exactly the same. So in that sense, she was successful. Those rules were ultimately passed or developed by Parliament, accepted by Parliament. She challenged them in court, and the court set her challenge aside in the end. So I think so many matters have been dealt with by the courts already that there's so few aspects, I would imagine, that's still outstanding and still can be challenged, that I think both Parliament as well as the presidency said, well, we are convinced that this is above board, that is constitutional, what is happening, and therefore continue.
But as you say, she's not necessarily plucking some of these things from the air. She's actually using the law to argue it. For instance, she's said that South Africa has violated her rights under Articles 7, subsection 1 and 26 of the African Charter, which relate to the right of an individual to have their case heard and the duty of the state to guarantee the independence of the courts. So would this be a matter of interpretation? Could there be somebody who agrees with that interpretation based on the legal statutes that she's pointing to?
Well, no, you know, for these statutes to be applicable in South Africa, they must become part of the South African law. They must become domesticated within South African law. And most of the international conventions, take for example the Rome Statute that established the International Criminal Court. There's a South African law that incorporates that into South African law. So these matters, if they are applicable on South Africa, they must first become part of South African law. But still, the highest authority in order to interpret that and to enforce that is the Constitutional Court. So if the Constitutional Court is of an opinion that this is not the case, that is not applicable to her case, I think that's more or less as far as she can go in terms of the South African law at the moment.
Well, thank you so much for speaking to us, sharing your thoughts. Political analyst Dirk Kotze, Professor in Political Science at the University of South Africa. And of course, Advocate Mkhwebane is also saying she wants South Africa to pay 50 million rand in compensation for damages suffered and legal costs incurred in the Western Cape High Court and the Constitutional Court. So this is the relief that she is seeking with her application to the African Commission on Human and People's Rights.